May it be the Lord. My Lord, we have filed, or I have filed three things, my Lord, a sort of detailed written submissions which I would like to place before your Lordships. And then, my Lord, there is a compilation of case law. And then, as my Lord had said, there's also a compilation of the rules. My Lord Justice Suryakant had said we should also file the High Court rules. So we filed those also in a separate compilation. If your Lordships take, we've also provided printed copies of the written submissions. If your Lordships either wants the PDF volume or the printed copy, either both are there. The registry asked us for printed right at the beginning, my Lord. In fact, it starts at PDF page. PDF page 3. PDF page 3 is the index, right? PDF page 3, yes. PDF page 3, and otherwise, my Lord, it's the index page of the printed copy. Your Lordships may have the printed copy, otherwise, no problem.
1 to 50.
That's right.
Some say convenience compilation.
Sorry, my Lord?
Amicus.
Amicus.
It's, my Lord, written submissions.
Yes.
My Lord, may I just start with the introduction, which is at page 1?
Yes.
Because this is, my Lord, the orders passed by your Lordships in this application that your Lordships are considering. It says, my Lord, by way of the present application, an anomalous situation in respect of the interstate seniority of district judges, direct recruits and district judges promotees has been placed. This Honorable Court's order dated 7th October 2025 recorded as follows. I'm just put two paras. This court, by the order dated 17th September 25, had considered an application filed by amicus who pointed out an anomalous situation in most of the states. Judicial officers recruited as civil judge often do not reach the level of principal district judge, leave aside reaching the position of a high court judge. This has resulted in many bright young lawyers being dissuaded from joining the service at the level of CJ. At para 10 and 11, this Honorable Court stated as follows. It cannot be disputed that judges who were initially appointed at CJ gain rich experience since they have been serving in the judiciary for a number of decades. Furthermore, every judicial officer, be it one who was initially recruited as CJ or one who was directly recruited as district judge, has an aspiration to reach at least up to the position of a high court judge. We are therefore of the view that a proper balance has to be struck between the competing claims. However, this issue would involve consideration of some of the judgments and orders passed by benches comprising of 3 learned judges of this court. Therefore, in order to put the entire controversy at rest and provide a meaningful and long-lasting situation, we are of the considered view that it will be appropriate if the issue is considered by a constitution bench of 5 learned judges. And then, my Lord, the question framed on the next date, which was 14/10/25, is as follows. What should be the criteria for determining seniority in the higher judicial service? So the question, though wide, is, my Lord, I have limited my submissions to the question as recorded in the 7th October order and, my Lord, the application to answer this question to the best of, my Lord, what we feel we should be placing. It is respectfully submitted that seniority in the higher judicial service in various states, which comprises of a single cadre of district judges, though further divided into posts of district judge entry level, district judge selection grade, and district judge super time scale, ought to be fixed in a manner that district judges appointed by direct recruitment and promotion from the cadre of civil judges have an equivalence and a balance be struck so that no one category has an advantage over the other in respect of the said cadre, as also for further aspiration to advance the position of principal district judge, if any, and further to the position of high court judges. I say if any because not all states have principal district judge designation. So that's why if any is mentioned over there. Otherwise, my Lord, some states have only district judge super time scale as the highest, and from there they are. My Lord, now if your Lordship just comes to the first page of the compilation, this is the way I've divided it into various, my Lord, submissions. I've just, my Lord, read the introduction. I've given a brief background, my Lords, then a small discussion on the cadre of district judges, and then, my Lords, for me to, or for us to impress upon your Lordship that there is a requirement of a quota, some data has to be given. I can't just say have a quota without, so that is, my Lord, serial number D, need or requirement for a quota. And then, my Lord's, fixation of seniority in the higher judiciary that deals with judgments also of your Lordships. And finally, a summary of submissions and suggestions. So this is the way I've divided this note into the 4 or 5 minutes portions. If your Lordship comes back to page 2, now this is where, my Lord, the issue was first considered. Para 5, the disparity in the cadre was noticed in the first National Judicial Pay Commission, also known as the Justice Shetty Commission, under the chairmanship of Honorable Mr. Justice K.J. Shetty in its report. The Justice Shetty Commission submitted its report on 11/11/99. The commission noted, I've set out some paras, my lord, for your lordship's consideration. The mixed cadre of district judges consisting of promotees and district recruits in every state judicial service was intended to promote efficiency in the administration of justice. But the fact remains otherwise. There is a lot of discontentment between direct recruits of district judges on one side and promotees on the other. The two classes are generally not on cordial terms. Nay, in some states, they are not even on talking terms. They are forming separate associations. They are locked in legal battles fighting up the apex court. They made separate representations to this commission. The root cause for all these unfortunate fallout seems to be the mode of direct recruitment followed by high courts and determining the inter se seniority between promotees and direct recruits. The high courts are not unaware of this bitterness and discontentment in the service, yet seems to have done little to improve the method of direct recruitment so as to remove the grievance of promotees. The common grievance of service judges in the lower cadre in all the states, and which grievance is also highlighted in the memorandum of All India Judges Association, is that the hopes and aspirations of judges who have entered the lowest rung of the judicial service have been shattered for want of adequate promotional opportunity. It was explained that the unreasonable quota reserved and unscientific method followed for direct recruitment of district judges have practically driven the service judges to despair and despondency. It was said that they could never think of becoming principal district judge. It was pointed out that advocates are recruited as district judges at a relatively younger age, varying from 32 to 40 years, while service judges would get a chance of promotion as district judges only at their advanced age. Such direct recruits should be ranked above the promotees in the seniority list and occupy all the central posts. They also deprive the promotees the chance to reach the High Court. In the light of the aforesaid, the Justice Shetty Commission recommended the following. It seems to us that it is proper and necessary for all high courts to have a uniform procedure for recruitment of district judges. There should be uniformity as to quota, minimum and maximum age and method of selection. Such uniformity is imperative since district judge cadre is a feeder service to the High Court and in some cases an onward march to the apex court. Since 10.80, since temporary posts are also available for direct recruitment, we consider not exceeding 25% of the posts in the cadre of district judges should be reserved for direct recruitment. This percentage of reservation would not jeopardize the interest of the promotees since we have decided to give them a certain weightage for fixing the inter se seniority, besides providing opportunity to service judges to compete for such direct recruitment. We consider that there should be a minimum age for direct recruitment and it should be not less than 35 years. To put it more explicitly, the minimum age should be 35. Next, my lord, the Shetty Commission further noted that district judge entry level were provided career progression by way of grant of functional scales in the form of district judge selection grade and district judge super time scale, depending on their performance, and recommended that the cadre of district judges should be divided in the following manner. We have carefully considered the representations of High Court, state governments, and state and service associations. In our opinion, it is necessary to bring out uniformity in giving selection grade and super time scale to district judges in all the states. It is also necessary to prescribe the minimum qualification for entitlement to such grade or scale. These two scales are not to be considered as career progression scales. They are functional scales depending on performance. Commission recommends 25% of posts in the cadre of district judge in each state shall carry selection grade. This may be given on the benefit of merit cum seniority, on the basis of merit cum seniority to those who put in minimum experience of 5 years in the cadre. Commission further recommends minimum 10% of the cadre strength in district judges be given super time scale to those who have put in minimum of 3 years in the cadre of selection grade. Now this has become 35 and 15. Latest judgment of your lordships has amended that. Next, recommendation in respect of seniority is at the bottom of the page.
No. Become 25.
Sorry?
That's
No.
become 25.
No, Milord, I was talking about the selection grade and the super time.
Super time. Yes.
Because that is what page 4 is on. Otherwise, the lordships are right. It is 50% for in the cadre. 50% are directly promotees, regular promotees. 25% direct recruits and 25% limited competitive examination.
LCD.
By this one, LC. My lord, may I just continue reading this a little bit?
Yes.
My lord, 12.106 bottom. This is the recommendation in respect to inter se seniority. Bearing in mind the aforesaid perspectives, comments, and suggestions made by High Court, state governments, judges, and service associations, we have made the uniform rules of recruitment and seniority for operation of all the states and union territories. the rules of recruitment inter alia provides as follows. Reservation for direct recruitment from members of the bar to the cadre of district judges should not be more than 25% of the cadre posts. This is a simple rule prescribing the upper limit for direct recruitment without any prescription of rota quota system. Then, my lord, the next is the age is between 35 and 45, and then the examination. And please come, my lords, to Roman 6, which is the rules of seniority. Seniority of the officers appointed by direct recruitment or promotion shall be determined according to the dates on which they report for duty. Where more than one officer is promoted to a cadre at the same time, inter se seniority of the persons who are promoted shall be determined by the inter se seniority in the lower cadre. With regard to direct recruits, inter se seniority is determined on the basis of the rankings in the select list. Weightage for promotees. According to the feedback information which we have received from the high courts regarding average age of promotees and direct recruits made in the last 5 years to the cadre of district judges, the promotees will always be older in age to direct recruits. Reason being, civil judges senior division get promotion as district judges only at their advanced age, while bar members are directly recruited at a younger age. Then, there is a chart appended to the Justice Shetty Commission, which your lordships will see the difference in the various states. In Andhra, for instance, average age of promotee district judge 48, average age of directly recruited 39. Then Assam 51-38, Bihar 54-41. So in virtually every state there is that age disparity. So this is why now this, my lord, is now dealt with at 12.110 and 12.111. It will be seen from the above table that average age of promotees would be about 50 years as against the average age of 42 years of direct recruit. Indeed, the table shows that in a majority of the states, such average age of the promotees would be above 50 years, while that of all direct recruits would be less than 42 years. Just pausing here, I have also compiled my own chart from the affidavit filed by the High Court about the position today, which is later on in the submission. So, lordships may just see, in 1999 itself, the difference was 50 and 42. And now today's position I will be showing to your lordship. 12.111, my lord. This will have an imbalance in the service conditions of promotees and direct recruits, and that is the root cause of frustration amongst the promotees. Apart from the imbalance in service, promotees would be denied of higher pay scales like selection grade, super time scale, etc., since it is given on the basis of merit and seniority of the officers. Promotees will not have any chance to become principal district judges of districts, since such posts are generally occupied by senior judges. They would be wholly denied of opportunity to go side by side with direct recruits in their onward march to reach the High Court. Even if they are elevated to the High Court, they will have hardly 3 or 4 years of service. Such a short period is not sufficient to make any worthwhile contribution to the High Court. The Commission considers that it is imperative to remove the frustration of promotees resulting from the aforesaid imbalance, and the only way we can think of is to give certain weightage to the promotees for the purpose of determining their seniority. The system of giving weightage is not new to service jurisprudence. It has been provided to officers of the state service when they are selected to all India services. The reference may be made to the Indian Administrative Service Rules. Then, 12.119. The Commission recommends that promotees be given a weightage of 1 year for every 5 years of judicial service rendered by them, subject to a maximum of 3 years. So, pausing here, so suppose a civil judge is recruited and spends, let's say, 15 years in the combined cadre of civil judge, junior division, and then senior division. For those 15 years, if that person gets promoted to to a district judge, will get 3 years benefit of seniority. Otherwise, he will start from the bottom. But this is the recommendation that the Justice Shetty Commission said. Sorry. Then, 12.120. Judicial service of officers for providing weightage is the entire service rendered by them as judicial officers, right from the entry into judicial service up to the date of promotion to the cadre of district judges. And so the next, is a summary of the above. And then, what your lordships had held in this very case in 2002 4 SCC 247, while considering the Justice Shetty Commission recommendations, is set out at para 10. Experience has shown that there has been a constant discontentment amongst the members of the higher judicial service in regard to their seniority in service. For over 3 decades, a large number of cases has been instituted in order to decide the relative seniority from the officers recruited from the 2 different sources. namely promotees and direct recruits. As a result of the decision today, there will be, in a way, three ways of recruitment to the higher judicial service. The quota for promotion, which we have prescribed, is 50% by following the principle of merit cum seniority, 25% strictly on the basis of merit by limited departmental competitive examination, and 25% by direct recruitment. Experience has also shown that the least amount of litigation in the country where the quota system of recruitment exists, insofar as seniority is concerned, is where a roster system is followed. For example, there is, as per the rules of central government, a 40-point roster which has been prescribed, which deals with quotas for scheduled castes and scheduled tribes. Hardly, if ever, has there been litigation amongst the members of the service after their recruitment as per the quotas. The seniority is fixed by roster points and irrespective of the fact as to when a person is recruited. When roster system is followed, there is no question of any dispute arising. The 40-point roster has been considered and approved by this court in R.K. Sabharwal versus State of Punjab. One of the methods of avoiding any litigation and bringing about certainty in this regard is by specifying quotas in relation to posts and not in relation to vacancies. This is the basic principle on the basis of which the 40-point roster works. We direct the High Courts to suitably amend and promulgate seniority rules on the basis of the roster principle as approved by this court in R.K. Sabharwal case as early as possible. We hope that as a result thereof, there would be no further dispute in the fixation of seniority. It is obvious that this system can only apply prospectively, except that where under the relevant rules, seniority is to be determined on the basis of quota and rotational system, the existing relative seniority of members of the higher judicial service has to be protected, but the roster has to be evolved for the future. Appropriate rules and methods will be adopted by the High Courts and approved by the states whenever necessary by so and so. Then, next, we disapprove the recommendation of giving any weightage to the members of the subordinate judicial service in their promotion to the higher judicial service in determining seniority vis-a-vis direct recruits and the promotees. The roster system will ensure fair play to all while improving efficiency in the service. Subject to the various modifications, all other recommendations of the Justice Shetty Commission are accepted. So, my lord, the weightage system which was then recommended by Justice Shetty Commission was rejected, and the court took the view that you will follow the 40-point roster for appointment as well as seniority. 40-point for roster and seniority. Now, my lord, please see, one of the things that has arisen, and will come later in the note, is that let us say, my lord, the 40-point rosters worked when district judges entry level are appointed. Now, to the next grade, let's call it, my lord, the promotion, because most high courts call it promotion, although it is actually a functional upgradation as per Justice Shetty Commission. But let us call it promotion by merit cum seniority. My lord, there are no seniority rules, so the 40-point roster remains. In other words, what is happening is that people are actually being promoted more on seniority than merit. Otherwise, my lord, if it is merit cum seniority, then there has to be some change in seniority. The roster, 40-point roster will obviously be changed once, my lord, we go from entry level to selection grade, from selection grade to super time scale, if merit cum seniority is being applied. But in almost all states, it is virtually, my lord, the same roster system, which is being for the entire card. And one of the reasons for that is, my lord, that the merit, determination of merit, some high courts rules have pointed it out and I'll show it, is basically on ACRs. Now, most people have those ACRs, 2 good, 1 very good, etc. That. So it all comes to seniority. So the criteria for merit is determined in a manner that seniority becomes the main thing. I'll show that in my submission. Would your lordships turn over the page to page 9? Thus, this Honorable Court in terms disapproved the recommendation of the Justice Shetty Commission with respect to determination of inter se seniority of promotee district judges and direct recruit district judges, and did not grant the promotee district judges a weightage of 1 year for every 5 years of judicial service rendered by them, subject to a maximum of 3 years. Instead, this Honorable Court held that inter se seniority should be determined on the basis of 40-point roster, as has been considered and approved in R.K. Sabharwal. In the same judgment, this Honorable Court also held that the cadre of district judges would be divided in the ratio of 50 regular promotion as to 25 accelerated promotion as to 25 direct recruits. Thereafter, in All India Judges Association 2010, 15 SCC 170, this Honorable Court altered the ratio from 50-25-25 to 65-10-25 for appointment to the cadre of district judge. Recently, this Honorable Court in All India Judges Association, while relaxing the eligibility conditions for appearing in limited departmental competitive examination restored the ratio for appointment to the post of district judge as 50-25-25 in the following manner. We find that if the quota of LDCE is restored to 25%, as originally recommended in the third AIJA case, which was reduced to 10% in the fourth AIJA case, it will provide an incentive amongst officers in the cadre of civil judge senior division. It will also provide them with an opportunity to get accelerated promotion in the cadre of district judge if they are meritorious and deserving. Another difficulty that has come to our notice is that sufficient number of candidates are not available for appearing in LDCE on account of requirement of having 5 years experience as civil judge senior division, which is prescribed as an eligibility criterion for appearing in the LDCE for the higher judiciary. In some of the states, a judicial officer who completes about 5 years service in the cadre of civil judge senior division in normal course becomes entitled to be promoted in the cadre of district judge. We have already framed issue 2 dealing with this very conundrum, which we are considering immediately after this issue. We find that in view of the answer that we propose for issue 2, sufficient number of judicial officers from the cadre of civil judge senior division would be available who would be eligible for appearing in LDCE. If in a particular year sufficient candidates are not selected from LDCE quota, it will be appropriate that such posts would revert back to the regular promotion quota based on merit cum seniority to be filled up in the same year. Therefore, in such a case, we find that no adverse impact on the administration of justice would occur even if LDCE quota is increased to 25%. In our view, this, apart from avoiding any adverse effect on administration of justice due to sufficient number of seats not being filled up, would also ensure that no prejudice would be caused to regular promotees, and at the same time, the said exercise would provide an incentive to meritorious judicial officer if their merit deserves the same. The next paragraph, my lord, your lordships have set out the time it takes. Now, this will also apply to our case that we are presently dealing with here. We find that it will be appropriate to compare the position in some of the states with regard to average time taken by civil judge junior division to be eligible for LDCE as against average time taken by civil judge junior division to become a district judge by way of regular promotion. In this respect, a chart was submitted extracted as under. Now, my lord, please see Bihar. Average time taken by civil judge junior division to be eligible for LDCE is 9 to 10 years. Not very relevant for us, but the next one. Average time taken by civil judge junior division to become a district judge by regular promotion is 9 to 10 years. If we come to Himachal, my lord, the average time B by a civil judge to become a district judge by regular promotion is 19 to 20 years. In Maharashtra, my lord, it is 13 years. So, the reason I'm pointing this out is now we have seen the 99 position in the Shetty Commission report. This is the 25 position which your lordships have set out. In Maharashtra, my lord, average time taken by civil judge junior division to become a district judge by regular promotion, 13 years. Next, my lord, Manipur. Average time taken by civil judge to become district judge by regular promotion, 11 years. In Punjab, average time by civil judge to become district judge regular promotion, 15 years. Haryana, 12 years. Uttar Pradesh, 9 to 10 years. Now, what your lordship said was that in the context of LDCE, the time that you became eligible for LDCE and regular promotions was almost the same. Therefore, there was no need for, people are not appearing in LDCE. So, therefore, your lordship reduced that time. But, my lord, what I am presently placing before your lordships is the time it takes for a civil judge to become a district judge is so long that, again, my lord, the age disparity will remain. And what that age disparity is, I'll show it to your lordship. Then, my lord, if para 42 at the bottom of page 11, as has been discussed herein above, the purpose behind providing a special quota for LDCE is to enable meritorious judicial officers to get accelerated promotion and enter the cadre of district judges at an earlier point of time than other less meritorious candidates. If a judicial officer even otherwise gets an entry in the cadre of district judges after completion of 5 years of service as civil judge senior division, there will be no incentive available to him or her. As already discussed herein above, in some of the high courts, a judicial officer gets into the cadre of district judge through regular promotion itself after he or she completes 5 years service as civil judge senior division. Therefore, in our considered view, it will be desirable to modify the requirement to become eligible for LDCE for the higher judicial service and reduce the minimum number of years of service of experience as a civil judge senior division from 5 to 3 years. However, at the same time, we are also of the opinion that, as recommended by some of the states, total number of years of experience for a judicial officer for being eligible for LDCE should be a minimum cumulative of 7 years, including service as civil judge junior and civil judge senior division. So this was in the context of saying that since you're taking the same time either way, you should reduce it. But what I am placing before your lordships is please see the time taken for regular promotion. We are presently mostly concerned with regular promotion here. That still remains. Now, my lord, the next heading is the cadre of district judges. This very short, my lord, just one page on that. The second National Judicial Pay Commission in its report dated January 2020 recommended, having regard to the long passage of time since the recommendations were made by FNJPC, an undeniable fact that quite a number of district judges are not reaching higher grades, this commission is of the view that it would be appropriate and proper to increase the percentage of ceiling prescribed by FNJPC to a reasonable extent. Commission recommends that selection grade and super time scale posts shall be increased by 10% and 5% respectively. This means that district judges at entry level shall be 50% selection grade, 35% selection grade 35% and super time scale 15% of the total cadre strength of district judges. Of course, the criterion of merit cum seniority shall continue to be applied for placing the district judges in these two higher grades involving functional as well as financial upgradation. We recommend accordingly. This recommendation, if accepted, may be allowed to come into force from so and so. Next, my lord, para 16 in part 1, volume 4. The posts of district judges selection grade shall be increased to 35% of the cadre strength as against 25%, and district judge super time scale shall be increased to 15% of the cadre strength as against 10%. It will be effective from 1/1/20. Now, this, my lord, these recommendations were considered by your lordships in 2024 1 SCC 526, and at para 74, this is what your lordships had held. This commission has recommended the increase the percentage of district judges who will be entitled to district judge selection grade and district judge super time scale. The reasoning of the commission is that due to limited percentage of district judge super time scale and district judge selection grade, many judges from larger states are unable to reach higher posts before retirement, even though they have spent considerable time in the district judge cadre. It is found that as of October 2019, only 1515 judges out of a cadre strength of 7382 district judges were getting the benefit of selection grade and super time scale. Recommendation of commission that the selection grade and super time scale posts should be increased by 10 and 5% respectively on merits acceptance. Essentially, this would entail that district judges at entry level shall be 50, selection grade 35%, and super time scale 15%. Now, Lord, so this was increased for the reason that judges should get an incentive to be in at least higher pay scales, and from there, Lord, you move to the High Court. Now, it will be worthwhile to see how many of these people, these judges may not reach selection grade and super time scale if you are a regular promotee judge coming from the civil judge senior division and before that from senior judge junior division cadre. And that's 50% of the cadre. We are dealing with 50% of the district judge cadre. What are their opportunities to reach these three scales within the district judge cadre? First scale, of course, is entry level, selection grade, and super time scale. Because that, I believe, is at the heart of what we are placing before your lordship. Now, my lord, according to us, the justification for that, we have tried to place, my lord, at page 13 onwards, which is the need and requirement for a quota. We are saying that there should be a quota. What that quota shall be, I'll come to your lordship. So the first is the Justice Shetty Commission, my lord. As mentioned above, Justice Shetty Commission had noted that there was disharmony amongst promotee judges and direct recruit judges in district judge cadre, especially due to different average age at which promotee judges 45 to 50 years and direct recruit judges 35 to 40 years joined the cadre, which left to limited avenues for career advancement of promotee judges due to superannuation before being considered for the post of principal district judge or above. It was specifically for this reason that the Shetty Commission had recommended to grant the promotee judges a weightage of 1 year for every 5 years of judicial service rendered by them, subject to a maximum of 3 years. However, the said recommendation was expressly rejected by this Honorable Court in this 2002 4 SCC 247. The Honorable Court instead recommended adopting 40-point roster to govern the interstate seniority. It is respectfully submitted that the 40-point roster system, while determining the interstate seniority of district judge and promotee judges at the time of joining the cadre, does not remedy the problem of age gap at which the direct recruit judges 35 to 40 years and promotee judges 45 to 50 years join the cadre. The effective result of the 40-point roster system is that once the promotee judge is superannuated to the higher age, the district direct recruit judges get clubbed together at the senior most positions in the seniority or gradation list due to the relatively younger age, and this stagnates the career progression of promotee judges. Despite having 20 to 25 years or more of judicial experience, due to seniority as determined by roster point system, promotee judges do not fall within the zone of consideration for being appointed as principal district judge. So what this para is essentially saying is, because they're at a higher age, they'll obviously superannuate much earlier, reach the age of 60 much earlier. So, my lord, because they may be, let us say, senior to a direct recruit judge, but the promotee judge will retire. Then the next promotee judge will also retire. So the top of the cadre will have, my lord, direct recruit, direct recruit, direct recruit, direct recruit. And, my lord, then when the question comes for appointment, if whether to the High Court or even to the next higher grade, it will be those people who will be taken into consideration. I've put a chart on the next page. I'll show that to you. Para 20 minutes. That the post of principal district judge in some states, others only have the post of district judge super time scale. Per se is not a promotional post itself, but an administrative post where a judicial officer from among the senior judges in the district judge cadre is appointed by respective high court for administrative efficiency and management of a judicial district. Promoted district judges with adequate judicial experience may not even fall within the zone of consideration for appointment to the post of principal district judge. Creation of such a quota will not only be beneficial to promoted district judges, but will be equally beneficial to direct recruit judges who in several other states have been found to be not adequately represented at the senior post in the cadre of district judge. Having a quota for promoted judges and direct recruits will ensure that judicial officers coming from both streams have equal opportunity of progressing and gaining career advancement. So, my lord, we are saying that 25% plus 50% is the promotee judges, 50% regular and 25% LDCE, and, my lord, 25% direct recruits. Now, please see the way I put it or tried to put it to see how, my lord, the quota helps everybody. It's one stream should not get the benefit, but both can get the benefit together is the way I'm trying to put it. The next page, now. The need and requirement of quota in the cadre of district judges may also be examined from the data on record provided by various high courts. So this is today's position. In certain states, it has been noted that an anomalous situation has arisen as per seniority gradation list of district judges, wherein it has been noted that the senior most district judges are found to be mostly direct recruit district judges, thereby leading to a lopsided situation where although the overall cadre strength of district judges is found to be in the ratio of 50:25:25, yet the post of principal district judge oblique district judge super time scale is occupied mostly by direct recruit district judges, and promoted district judges are not adequately represented at the post of principal district judge. This happens mostly due to average younger age of direct recruit district judges at the time of appointment to the cadre vis-a-vis the age of the promoted district judges. So this is exactly what Justice Shetty pointed out in 1999. Exactly the same. Now please see this chart. The following chart shows the difference in average age at the time of appointment of direct recruit judges and promoted district judges. Now, my lord, your lordships will see 35 in Andhra, 35 to 40. Sorry. Sorry.
Kerala, you have said 49 is the direct entry position.
Sorry, madam.
The
Yeah.
direct entry district judges, they get into the service at 49.
Right.
In Kerala, now there are at least 5 High Court judges who are direct entry people,
Right.
who are at this age, 49.
Oh, I see. No, I've just given the average. Maybe.
This is not correct.
So I'll just recheck it. This is my own, my lord.
It must be 39, 40.
Just check out the. My lord, I'll just quickly check. I may have made a.
Same thing with Bihar.
Let us see Bihar. My lord. The Bihar is not.
Bihar is not seen shown here.
So they, whoever's provided the data, I put it. The rest we have not been able. But my lord, just one thing to be added here. When your lordships are seeing this, this
Right, in Bihar, it takes 17 years to become district judge.
For the promotees.
for promoting.
No, no,
17
I'm
years
talking about the
on direct
recruits. I'm talking about the direct recruits.
My lord, I'm quickly checking the Kerala affidavit. Maybe it's a mistake. But one thing, your lordship will just note one thing here. The figures are, I think, more or less correct.
Yeah.
But my lord, when we come to the third, fourth column, average age of appointment to district judge, promoted judges, please add to this 3 years. Because now your lordships have said that you have to have 3 years as an advocate before you even take the examination. This data has come. This data is before this requirement has come into the picture.
53 will become 56.
Now, my lord, you add 3 years to it. Your lordship's judgment of 2025 May, when it was discussed at great length, and the Bar Council of India also said, and all the High Court said that
Almost all the High Court.
every High Court said that you just, except 1 or 2 Sikkim, etc., that you just can't have untrained, people without any advocacy experience becoming civil judge, deciding life and liberty. And so your lordship then mulled over whether it should be 2 or 3 years, and your lordship said 3 years. So now in this second last column, you will have to add, my lord, your lordship will have to add 3 years. What does it say? My lord, I'll just read that affidavit of the Kerala High Court. I'm sorry, I've taken it from here. I'm reading it, my lord, from here, if with your lordship's permission. Average age of judges presently serving in the cadre of district and sessions appointed by promotion from the cadre of civil judge senior division is 53 years, while the average age of judges directly recruited in the cadre is 49 years. So they've said on affidavit it may be.
Except that average age of judges now serving is 49,
Yes,
not recruitment.
correct. Your lordships are right. That's a mistake, yes.
I would say.
Hmm.
These aged persons serving as PDG.
Please, we have
Right.
three of them who have first-hand knowledge, one on this
No,
side,
so, my lord,
two on the other side.
no, I accept my mistake. When going through so many affidavits, sometimes a little bit of. But all I'm saying is for this chart, please, my lord, while considering this, add 3 years in the second last column. That will have to, your lordship will have to add. Because, and minimum 3, because we are assuming that a person immediately after 3 years becomes a civil judge junior division. So minimum 3 your lordships add. My lord, just come into the next page 16. My lord, my apologies for that. I'll just correct it.
Here.
Just check the others if there's any mistake. Affidavits keep coming and you quickly just sometimes write and this doesn't really.
Case settled in 2025.
Yeah, luckily your lordships have that experience, your lordship immediately corrected me. So. But in fact, what your lordships are saying that the difference would be more than what I've indicated, not less. So it's, sorry. Hmm? Which example? Let's do it now.
There can't be an entry below 35.
Yes. Minimum is 35. My lord, just see, my lord, may I just, now that we are mulling on this issue,
Both. Direct issue.
oh, Kerala, there are 42 and 49, no? No. Okay. Yeah, correct. It's a much bigger difference. My lord, one of the examples given by my,
You see, this entire facts which you are referring to, this only highlight the anomalous situation,
correct,
according to you,
my lord,
that a kind of a explicit discriminatory
that's it,
or anomalous situation between direct recruits versus promoter.
my lord.
Those who are departmental, this limited
LC,
entry, 25%, to whom we can, just on loosely, we can call them semi-direct recruit.
right, my lord. Because they are getting a, yes,
So they
advantage,
still might have an edge or advantage of seniority, might,
my lord,
depending upon that what time they compete and what time they get acquire eligibility and enter.
that's right.
Now this entire anomalous situation, what is the ultimate recommendation?
So, would your lordship want me to come to that first and then come back to it? Very well, I can mention that. But before I could do that, can I just mention 2 aspects, which, my lord, since your lordships are on LCE right now, just now, and also, my lord, recently we had a judgment of a constitution bench which says that even, my lord, serving civil judges after 7 years can take the direct recruit examination because the experience there is actually much more than that of an advocate of 7 years. That's what your lordships have said. So, my lord, one of the points that my learned friends have said, and it's a point worth, my lord, dealing.
Therefore, balancing of seniority
Yes,
is now also important because of that judgment.
right,
If you give so much incentive to the seniority for the direct recruits,
correct.
our junior cadre officer will start only working for,
Then-
competing.
And they will not be interested in deciding cases, they will study for the examination.
Have a crisis in junior division level.
Exactly, my lord. So you will spend 7 years preparing for the district judge direct recruit examination rather than doing, because then you are not bothered about your ACRs, etc., because you are only interested in taking the direct recruit examination. But my lord, please see two examples that I am giving. My lord, one of the things that has been pointed out, it's certainly something I should mention straight away, is that LCE, which your lordships pointed out, and even the direct recruitment now gives some kind of equivalence to other people, which would include promotee judges. Now, the way they've said is this, that let us say, my lord, the case where a person graduates at the age of 23 years. Let us, my lord, take an example from law college. Then, my lord, that person will spend 3 years practicing as an advocate as per your lordship's judgment for 26 years. And then, my lord, as per your lordship's judgment, LDC, they can take after 7 years minimum. So, my lord, let us say 26 plus 7, 33. So, they are saying that at the minimum age, if you clear everything in the first round, you will at the age of 33 itself become eligible to become a district judge.
So 35 is the.
35.
But so 33, but you take it to, so therefore you have no disadvantage. I was coming to that. 33 through LDCE, 33 to LDCE, but let us say you are appointed at 35 only. So the argument is there is no disadvantage. I am just dealing with that argument. Next is, my lord, let us take a case of a civil judge who after 7 years, as per, my lord, your lordship's judgment in the review in Dheeraj More, takes the examination and clears it. So, my lord, in his case also, he would have joined at the age of 23. Let us say, my lord, finished law at 23, 3 years, my lord, of advocacy practice, and then, my lord, 7 years. So that takes it to 35. So,
We have made it that even in their case,
yes,
they can't get in before 35.
they can't get in before 35, but the argument that is being made is that therefore there are enough avenues for you through LDCE or through us for a civil judge to take the direct recruitment examination to come in at the age of 35.
And
Now,
so-
answer to this, let me give the answer. Sorry.
So their condition would be, whoever are meritorious amongst the promotee, they would have already made it by either through LCD or through the direct recruitment.
Right. So that is one of the arguments. Now, but please see the other side of it. 50% of the entire cadre is not promoted district judges. We are dealing with 25% LCE and assuming that the entire 25% is filled up. Your lordships have seen that in that matter when your lordships heard, hardly anyone was taking LCE. Now they will take because of the incentive. And my lord, you are assuming that every civil judge after 7 years will clear the district judge examination. So for 50%, we are dealing with the 50% of the cadre here. So, my lord, for them, the seniority and, my lord, promotion is a very important aspect. That's what I'm trying to say. So, my lord, to say that they've got opportunities, even after taking those opportunities, 50% of the cadre will still remain regular promoting cadre. So, we have to, so your lordship may think of that as that's what I'm trying to say, bro. Now, so, my lord, tell your lordships what my suggestions are and then I'll come back to this. Would your lordships come to, my lord, to page 48? I've dealt with the case of the same, 48. I've given 4 suggestions in the alternative, etc. Try to be, my lord, as even-handed and fair as possible. My lord, just have a look at it. My lord, may I read suggestion 1 at page 48, Roman 1. The additional experience as judicial officers constitutes a reasonable and justified classification on the basis of which promoted district judges can be classified as a category who ought to be granted a quota for their effective representation at the post of district judge selection grade, district judge, super time scale, principal district judges. Creation of such a quota satisfies the twin test of classification based on intelligible differential and reasonable nexus of such classification with the object sought to be achieved. Therefore, creation of such quota is permissible in terms of so-and-so. It is thus suggested that for appointment to the post of so-and-so, now, my lord, here, I'll just make there's a nuance here, which I'll just point out, to the post of district judge selection grade, district judge super time scale, principal district judges, a quota of 1:1 for promoted district judges and direct recruit district judges may be created. Principle of merit cum seniority can then be applied within the said quota. So what the suggestion finally is that even for that 25% direct recruitment, you have a 50% quota, and for that 75% entire, my lord, promoting cadre, you have 50%. That your lordships can, of course, make it 75, 25, 25. Also, some of my learned friends on this side are arguing that. But here, my lord, your lordship will have to see one nuance, that this district judge cadre has, my lord, 50% judges at entry level. 35% at selection grade, and 15% at super time scale. So, my lord, if we let us assume for a minute that this 1:1 quota is to be applied, and we apply it to both selection grade and super time scale, then there will be no entry level direct recruit district judge left, because 17.5% plus 7.5% will go into the next two posts. So, my lord, my suggestion here therefore will be to have that at the super time scale.
Only.
I hope I've made myself clear. My lord, let's say there are 100 posts in the cadre. So there will be 50 Milord entry level, there will be 35 selection grade, and 15 Milord super time scale.
Mr. Bhatnagar, that 25% departmental examination,
Yes,
the 25% quota, is only meant for as an incentive
yes,
for the officers who we suppose that they are meritorious enough,
Right.
that they can, through competitive exam, they can occupy those 25%.
Right.
What will be the incentive for them left if you apply this ratio in principal district judge or selection grade? And
no, because they will still be they are still promotees. Of course, but no, the incentive,
therefore, within, why they should compete for 25%?
no, so,
If ultimately, this position is to be occupied solely on the basis of length of service, then what is the incentive left for them?
for the LC, yes.
25%.
No, then, my lord, you will be senior to a regular promotee in any case in the seniority list. You will have a quota, yes, but your seniority will be higher.
Then are you conceptualizing a situation
Yes, sir.
where the senior most person in the cadre of district judge, though he is senior most, but he will not get a super time scale or he will not get a selection grade?
No, I'm not visualizing that. In fact, I'm saying the opposite. I'm saying the senior most, suppose, my lord, the LCE person, let's say, my lord, there are two promotees appointed on the same day. One of them clears LCE at a younger age.
If on the same date they are promoted,
Yes.
nothing difficult, because then you can say that promotees will have an edge over the department
Right.
appointed promoter.
My lord.
let us say. Then he can be assigned seniority. You can have kind of a roster point. You give first point to the promoter.
That's it.
Second
That's how the
to
roster
him,
is also.
and
Yes.
third maybe to the direct report.
Correct.
That is one possibility. But what will be the incentive left for an officer?
Yes.
He will say, why should I work hard, compete, and try to qualify the exam when eventually, in terms of seniority or in terms of monetary benefit of a higher pay scale, I'm going to lose?
The benefit will be, in my respectful submission, this, that suppose, my lord, there are two civil judges, senior division, one is junior to the other. The junior one passes the LCA examination. He comes directly into the cadre of district judges. He becomes senior to the regular promotee when he comes in. So, my lord, the seniority will be higher in the cadre in any case. The quota doesn't affect seniority. Yes. Right. What I was saying, just, just to come back to what your lordship very rightly put to me. Firstly, at the entry level, we are not fixing a quota. So the LCE will anyway be senior. So entry level, will be as per roster, as my lord said. Only at super time scale will, the promotees get. Now, that's one. Secondly, if, I have just in fairness mentioned 1:1 as an amicus, but suppose some of my learned friends, etc., are saying the quota should be 2:1:1, that is to say, 2 for regular promotees, 1 for LCE and 1 for direct recruit. Suppose that is accepted by lordship, then LCE again will get the same.
Ultimately, 2:2 only.
Yes. I'm saying that, but ultimately I'm saying that the regular promotees are the ones who suffer the most because being maximum in the cadre. Coming to suggestion 2, which is the next page, page 49. Now here, it's the same as suggestion 1, except here we are saying something a little different. Alternatively, zone of consideration for appointment to the post of district judge selection. So please read this: zone of consideration for appointment of district judge selection grade and district judge super time scale should comprise of 50% officers from directly recruited district judges and 50% from promoted district judges. Thereafter, appointment would be made on the recommendation of the respective high courts on the basis of merit cum seniority. Thus, in the zone of consideration, 50% shall be senior most promoted district judges and 50% shall be senior most directly recruited judges. Now, suppose, there are 10 posts. So most high courts have a system where, the zone of consideration is 3 times. So let us say 30 officers, 30 judges will be considered. Now, out of which my suggestion is that in this zone of consideration, you will have 15 from the senior most promotee and 15 from the senior most directly recruited. After that, if the High Court feels that all 10 should be directly recruited judges appointed to the next grade, that is for the High Court to decide on merit cum seniority, or 5:5 or 10:0, whatever. But this is the zone of consideration argument, so that at least somebody comes within the zone of consideration. Otherwise, they are not in the zone of consideration. If it's 3 officers to be considered for 1 post, then obviously because of seniority, etc., they're never in the zone. This will bring them within the zone. This is the second argument. So this can be an alternative to the first in case your lordships feel that this is a better one.
Mr. Marcus, your suggestion, second suggestion, in fact, will create a cadre within a cadre.
Why is that? I'm sorry.
Because you are saying that the 50%, let's say there are 10 candidates eligible for a super time or a special selection grade. It would be 5 from the promotees and 5 from the direct recruits. So what would happen is, at the district judge entry level, it's a common cadre.
Yes,
And if the second suggestion is adopted,
my lord.
then we are creating a separate classification, a cadre within the cadre of direct recruit judges as district judges and promotee judges as district
So,
judges.
with great respect, what I was trying to say is that they'll only be in the zone of consideration for being considered. Appointment can be of either of them, but they'll be the same. It's the cadre remains the same.
But for that, the list of seniority
Yes.
will be a different list of seniority for the district judges as direct recruit district judges and promotee district.
So that in
That is your proposal so
No.
far as.
so that is not exactly my proposal. I'm saying that in the same
That
scenario.
will boil down to that.
Correct. Now, but that is exactly what, in my fourth suggestion, the High Court of Andhra Pradesh has said exactly this.
We've seen it.
Exactly this,
But the area of consideration would be,
Yes.
do we create a stratification in the district judge cadre,
my
which is an uniform cadre itself? We can definitely consider your first suggestion about quota in
Yes, yes.
respect of the functional
That's the first-
seniority, functional position scales. But to create the cadre as groups will make it not an uniform, but a stratified cadre of district.
No, so I understand exactly what your lordships are saying, because then you are mixing up seniority in that sense. But my suggestion here is this is the only way in which if you are leaving it to the High Court to appoint a person and
It will also lead to a very anomalous situation
my lord.
where a person, because of this cap of 10 picking up from promoted, 10 picking up from direct recruit.
I'm not saying that.
No, zone of consideration.
Zone of
For zone of consideration.
Yes, yes.
10 you pick up from this side, 10 you pick up from this side, you merge them,
Merge them,
consider them, and then you promote them directly.
whoever you want.
Maybe that throughout till the question of designation or promotion as the principal district judge comes, an officer who have been throughout junior will become a head of the district judiciary, and all persons who have been throughout senior to him will be under.
No, that may not necessarily be the case, because the High Court will consider it when we're making that appointment.
If you restrict the zone of consideration, then nothing will left for the High Court. Then it depends upon that if he qualifies, then you can't stop him.
I'm saying that presently the zone of consideration is such skewed in the other way. For that, if your lordship just comes to page 16, just have a look at the seniority list.
Probably you want to suggest the High Court will have to then very adverse responsibility of seeing that in which session division we are posting him and no person junior to him should be posted there. This will.
No, no, that I'm not saying. But Milord, eventually, this is so, but Milord, I'll just show to your lordships how it works. In practice, what the problem is. I'll just show that immediately after I finish these suggestions. I'll come to the chart. There's a chart and I'll just show after this. The reason I've come out with this, that's just a suggestion for your lordships to consider. Milord, sorry. Milord, the third suggestion is in fact what the Justice Shetty Commission had said. So I'll read it out. Alternatively, it is suggested that this Honorable Court may accept the recommendations of the Justice Shetty Commission and grant weightage to promoted district judges for experience in terms of 1 year seniority for every 5 years of judicial service, subject to a maximum of 3 years. It is further submitted that these additional years of seniority may be considered as service in the district judge cadre. Thus, if a promotee district judge has been granted 3 years seniority as per aforesaid criteria, promotee district judge will require only 2 years of service in the district judge cadre for being considered for the grant of selection grade. This is the example I've given. It is stated acceptance of recommendation of Shetty Commission will require modifying or dispensing with 40-point roster system for seniority in so and so. Thus, it is respectfully submitted. It was respectfully submitted will address the issue of age disparity and additional experience of promotee district judge vis-a-vis district judge, direct recruit district judge. So this is exactly what Justice Shetty had said in 1999. The next one is what my lord has put to me, so I'll read that also. 4. Alternatively, this Honorable Court may consider the recommendation made by a committee of the Honorable High Court of Andhra Pradesh, which had recommended 3 separate seniority lists in respect of promotee district judges by regular promotion, promotee district judge LDCE plus direct recruit district judge in the ratio of their overall cadre strength of 50:25:25 and the selection of such higher posts in the cadre of district judges be made on basis of such seniority list. So these are the 4. One has come from the Andhra High Court, one is Justice Shetty, 2 I have put in, my lord, as my suggestions. Now, my lord, just to come back to page 16, I wanted to show your lordships a chart as to what, my lord, the issue comes.
Page?
My lord, 16. My lord, we have been able to call out the seniority lists of some of the high courts. And here your lordships will see, let's say, my lord, Kerala. This is the seniority list. So Kerala has promotee district judge, promotee. So fair number of promotees at the top. In Patna, if your lordship sees, district direct recruit, then my lord, some promotees, then direct recruit, and then everyone direct recruit. So here we feel that if all these promotees will be older in age, my lord, to the direct recruits, and they will all retire before the other direct recruits, and the entire cadre at the top will become direct recruits. That is one of the things. Similar
in Patna, that happened because 94 district judges were taken at one go.
It is mentioned in the affidavit. I'll show that.
That is why it
So that could be the reason. Yes, sir. The reason is not stated obviously in the
happened.
affidavit.
For 7 years, there was no recruitment at all.
Yes, ma'am. Right.
In Bombay, I think out of 21 studying I was appealing the other day, 18 or 19 are direct.
Yes. So all I'm trying to say is that this clubbing at the top is the problem. And the clubbing will happen because even if a senior promotee judge is there because of a 10-year age gap, he'll retire earlier. Or a 5-year age gap, he'll retire earlier. So that's the problem. My lord, turning to page 17, my lord, I've just culled out a few, my lord, paragraphs of affidavits on both sides, saying against and for both. Now, if your lordship looks at 17, this is what state of Uttar Pradesh is saying. Para 25, bracket A. In the state of Uttar Pradesh, there are 70 district and sessions judges, of which 58 are direct recruit district judges. So, my lord, these are actually principal district judges. Although they've called them, but these should be principal. 58 are direct recruit district judges, 12 are promoted district judges. High Court of Allahabad in its affidavit stated as follows. Out of 257, 137 officers are promoted judges by regular promotion, 2 officers are promoted judges of LDCE, 118 are direct recruits. Out of 100 senior most officers, 17 are promoted judges, regular promotion, 2 are promoted judges LDC, 81 are direct recruits. Senior most promoted judge features at serial number 29 in the seniority list. Therefore, posts at serial number 1 to 28 are occupied by direct recruits. The High Court is saying. Now, my lord, similarly for Bihar, your lordships had said there's a reason for it, but anyway, I'll place it. Out of 622 occupied posts, 91 judicial officers are working as principal district and session judge, consisting of 5 promotees and 86 direct recruits. As per seniority list and detailed chart, there are 20 direct recruit judicial officers presently below the 91 judicial officers working in the rank of principal district and session judge, meaning thereby that after the retirement of 5 promoting judges in the rank of principal district and session judge, all posts in the said rank will be occupied by direct recruit district judges. This is what, this is. Then some other, I will not read all of them, but just, if your lordship would just come to Andhra, because Andhra gave that suggestion, so let's see what they've said fully. That's at page 19, page para J. The High Court of Andhra has stated in its affidavit as follows: whereas candidates appointed to the post of district judge by direct recruitment are generally in the age group of 35 to 40, thus promoting officers always become juniors of direct recruits. Despite having put in more than 25 years of service, promoting officers retire in the cadre of district judges as they are junior to direct recruits and do not fall in the zone of consideration, and the judiciary is deprived of experience at High Court level. As per present seniority list, first 17 members were selected as district judges by direct recruitment, and considering their age, the promoted district judges will not get the opportunity to be considered for the post of High Court judges, even though they have put in 25 years of service. In the light thereof, the committee has made the following recommendations. Distinct seniority list should be maintained for each category of district judges: 1, direct recruitment; 2, recruitment by LDCE; 3, recruitment by promotion. Recommendations for appointment of High Court judge should be made within these specified categories. Initial appointment ratio for district judges shall be consistently applied for subsequent appointment as principal district judges and further for High Court. The committee unanimously resolved to recommend that that 50% of appointments to the High Court from in-service officers should be drawn from the category of district judges who were initially appointed in the cadre of Civil Judge Junior Division, ensuring adequate representation. This is not the issue today before your lordship, but this is what the High Court has felt. Looking at the skewed ratio there, this is what the High Court committee itself is saying. This is not one of my suggestions, or this is not even the issue here today, but I'm just telling you, pointing it out.
You were told that even in state of Tamil Nadu also there is similar.
Tamil Nadu, I'll just show it, that's, I think, mentioned here some, just 1 minute. Tamil Nadu in their affidavit have said that 37 principal district judges, 27 are promotees and 10 are direct recruits. That they've said. At page 22, I've summarized it. In fact, page 20 onward, this is the view of some of the other states who have said that either the ratio is the same or promotees are more. So that also I put in. So, my lord, Chhattisgarh, Gujarat, Himachal, Jharkhand, Madhya Pradesh, Mizoram, Tamil Nadu, Sikkim, Uttarakhand, West Bengal, Delhi, and my lord, Jammu and Kashmir. So they are saying that in their states there are sufficient number, if not more, promoting judges. They have said that, so I put that also for your lordship consideration. Now, my lord, the other submission which I had made, which has been now set out at page 23. Bottom, my lord. I'm just skipping over a few paragraphs because that we've already, my lord, covered that.